Welcome. I'm Ricky Revesz. I'm on the faculty here at NYU Law School, and I want to welcome you to the forum sponsored by Latham & Watkins. And the title for our forum today is Regulation in Transition, as we have a new president who was sworn in a week ago. He campaigned on the promise of undoing much of the Trump administration's regulatory output. And we will examine today how that can be done, what different tools are, which might work better and which might work worse, what the probability of success in these strategies is, and much more. So we'll have a fun 75 minutes. We have a great set of panelists. And I'm going to introduce them in the order in which they will speak. So first will be Sally Katzen. Sally is a professor here at the law school, a beloved teacher of legislation and the regulatory state. And probably the most significant thing in Sally's career is that during the Clinton administration, she was the administrator of the Office of Information and Regulatory Affairs. She's done a lot of other very significant things, but she's often referred to that way, and I think likes that, so I will do that. Bethany Davis-Snow, our second speaker, was until last week a colleague of mine at the Institute for Policy Integrity, where she served as our litigation director. But as a result of musical chairs caused by this transition, she is now the executive director of the State Environmental and Energy Impact Center, a center that used to be led by David Hayes, who went into the administration as special assistant to the president for energy and climate, and the deputy director was Elizabeth Klein, who was nominated by the president to be deputy secretary of the Interior. So Bethany is stepping into those shoes, and the State Impact Center is part of NYU Law School. It's one of the many institutes and centers that we have here. And Bethany also teaches here as an adjunct professor. And if we run out of questions, I'll ask Bethany what the difference between an institute, like the one she used to work at, is, and a center, like the one she works at now is. It's a very difficult question. Amit Narang is one of the most distinguished litigators in this space. He's a public policy advocate, a public citizen. And he's been very important and constructive participants on many of the debates that we'll be talking about today. So this is a fabulous panel. I'm delighted that you're here. The plan is that they will each talk for 7 minutes. First, Sally, then Bethany, and then Amit. I will then do some cleanup. I mean, talk about whatever I think they should have said but didn't, or things that their talk inspired me to say. Then maybe the four of us will have a little kind of like conversation. And after that, we will open things up for questions. You can start putting questions in the chat, and I will ask them at some point. And we have to stop at 12:15 Eastern time. So Sally.
Well, thank you, Ricky, and it's a pleasure to be here. Ricky gave you some of my background. Let me give you one more piece of information which influences and shapes my comments here today. I was the designated liaison for the Office of Management and Budget, OMB, from the Clinton administration to the George W. Bush administration. And then I took on a senior role in the Obama-Biden transition effort with responsibility for the White House and the Executive Office of the President and all the government-wide agencies like GSA, OPM, NARA, and whatever other alphabet soup you'd like to put together. And it's in that context that I'm going to start by setting the table and putting the whole issue of the regulations in place of how the transition itself works. And what you should know is that there's no cookie cutter recipe for transition. Each takes on the personality or style of the incoming president. So we had a very chaotic time with the Clinton transition. from George Herbert Walker Bush, and a no drama Obama transition from George W. Bush to Obama Biden. And I'll leave it to others to describe the Trump transition with its wholesale cleaning out of the staff that Chris Christie assembled, which was replaced by landing teams that were, I suppose, invading a foreign country, expecting armed resistance. But even though each has its own identity or character, there's some generalizations about the organization into which you'll want to put your discussion of regulations. First and foremost, transitions have resembled a three-legged stool, each leg of which has its own focus, and they operate independently but come together at a point, and that's policy, personnel, and what is usually called the agency review groups or teams. Now, basically, policy starts very early, often before the convention, and feeds into the campaign, and then comes into the transition organization to follow up to make sure policies articulated during the campaign or even committed to during the campaign are the touchstone for the transition and the first 100 days. And there's an element of purity police at play. He said it, he committed to do it, we have to do it. It would be heresy to modify that position, period. Full stop, no arguments, thank you. This means that to the extent that the candidate spoke about regulation or regulatory process, that's now gospel and will guide the people in the transition. Second leg is personnel. It's often less rigid in both organization and decision making, and there's two levels of personnel: the cabinet or major agency heads and the several thousand plus political appointees. Those in the former group are typically vetted by aides, but the decision is made by the president, looking for all the characteristics he holds dear, from competence to diversity, to confirmability, to compatibility with his philosophy. And the rest are sorted and interviewed and selected by the people who will eventually take the helm of presidential personnel, trusted aides of the president-elect. This tends to be a big black box, but it's a black box into which policy can sometimes reach to help influence, and as will the agency review groups. And therefore, you can get leaders of regulatory agencies who have walked through this landmine somehow and ended up where they are. So the third leg is the agency review team. And this is a team is created for each department or group of agencies, and they prepare memos setting forth everything they can about the agency, its mission, budget, number of personnel, job descriptions for political appointees, major programs, and major regulations that have come out that would be important for the incoming people to know about. And this is useful for presidential personnel because it guides their selection of their appointees. It's also a good starting point for the Senate confirmations, but it's grist for the mill on the regulatory front because you have a sense of what has been done. I remember vividly sitting in a room during the Obama-Biden, watching a screen of the GPO as the last week of the George W. Bush transition wound down. And we were going, oh my God, they released that reg. Oh no, that one came out. Oh. And as others will tell you, there's a difference between a reg in process and a reg which actually has taken effect.
2 minutes.
Thank you. The most striking thing to me about the agency working groups is that while they work hard and compile everything they can get their hands on, including interviews with senior civil servants and materials in the file drawers, so to speak, if the outgoing administration is cooperative, you cannot really know what the agency is doing or has done during the outgoing administration until you actually walk in the door on January 20th and start doing the job. It's always more complicated, more difficult, more variable. So these are the structures, and within this, there are two very important for our purposes groups. One looks at executive orders, reads every executive order that the previous administration had issued, and makes a recommendation as to whether it's benign or it's actually beneficial, let's keep it, or whether it's, oh my God, and we've got to get rid of it, or substantially modify it. And the second is on the regulations. As I said, I was in the room watching these things. The incoming transition gathers together all the work of the preceding administration and then makes recommendations about what to do about them. Are these things you can stop? Are these things that you'll want to use CRA, the Congressional Review Act, for? Are these things that you want to go into court and try to stop, hold in abeyance and remand to the agency? Are these regs those that the agency should just sit down and redo from scratch and rescind in that way? And I think that's what the other two panelists will be addressing, and then we can come back and with a wrap.
Wow, that was perfect, right on time. Thank you, Sally. So Bethany's next, and while Bethany starts talking, I want to remind you that you can put questions in the chat. We won't get them for a little bit. It's just nice to have them, and I can be thinking about them. So please do that. Bethany.
Hi, thanks so much for having me here. Sally, thank you so much for that description of the different pieces of this transition. What I'm going to talk about now is sort of the pressures that this group is facing. And to do that, we need to go back a little bit in time, and I will tell you a little bit about the Trump administration's transition, because it's going to have an ongoing impact, and we see the impact already. So obviously, when we have a new president, the new president wants to change policy and roll rules back. Right now we're in a new phase of rollbacks, rolling back the rollbacks. Before the Trump administration, repealing rules and these regulatory freeze memos that we just saw last week were sort of the traditional tools, but there were limits to those tools. So the regulatory freeze memo, or a stop work order memo, as it's called, is used by a new president to tell agencies to stop all work that they were working on for the prior president. Just put a freeze, take everything out of the Office of the Federal Register, don't publish anything, stop work on proposed rules, just pause. But those are most effective for obviously things that haven't been finalized and for things that haven't been published in the Federal Register. So they have a limit, those kinds of memos have a limited impact if you want to really roll things back. And then, the other traditional tool was repealing. That takes time. Agencies have to provide good reasons for their new policy. They need to explain their reason for disregarding the facts and circumstances that underlay the prior administration's rule. And it's not as easy to do a repeal if a rule's already been implemented. So that's an important feature that I'm going to come back to. So enter the Trump administration. He was a president who campaigned aggressively on the idea that he would roll back regulations issued under Obama. And so there's three tools that he kind of took to a new level. And these tools, the existence of these tools is placing a huge pressure on the new administration. So I want to run through these tools and sort of explain how they were used more aggressively by the Trump administration and why there's pressures on the Biden administration as a result now. Okay, so the first tool, Sally already mentioned, the Congressional Review Act. That's, Congress and the president aligned can disapprove a regulation issued by the prior administration. And before the Trump administration, that statute had only been used once to disapprove of the ergonomics rule, which was issued under Clinton. Under Trump, it was used 14 times to roll back rules right at the beginning of the transition. And then it was later in 2017, it was used against two other CFPB rules. So we just saw a huge expansion of interest in this statute. That's a new tool that puts pressure, which I'll come back to. The second tool is what are called abeyances, which is an order from a court that puts a pause on litigation. Traditionally, an abeyance is, useful to a court if the agency has said it wants to change its mind and issue a new rule, and the court wants to not spend resources on deciding whether the prior administration's rule is legal or not, but rather wait to see what the new administration is now going to do. And it's a useful tool for agencies. An agency will go into court and ask for the abeyance. And if they get an abeyance out of court, then they don't have to worry about a court saying that the prior administration's policy was legal. If this new administration wants to say it was illegal, it just opens up possibilities. And then the third tool is suspensions, or, quick changes to the regulations. And again, we saw, for abeyances with the Trump administration, we saw an aggressive use of these requests, even in cases where argument had already happened. So in theory, the court isn't expending additional resources if it decides that case, because it already, had argument, read all the briefs, and the new rule is a long way to, potentially a long way out there. Like the next administration, in this case, it was the Trump administration, was still years away from issuing its repeal of the Clean Power Plan, for example. And so the traditional justification for an abeyance didn't exist, but the Trump administration asked for abeyances sort of across the board and generally got them. So that's the second tool. And the third tool is suspensions. The Trump administration used them much more aggressively than prior administrations, used them in cases where the rules were already effective. And then it used them in a serial fashion. If one suspension was challenged, then it would withdraw that and issue a new suspension. At Policy Integrity, we run a tracker on the Trump administration's success rate in court. And, overall, when the Trump administration has used agencies to make policy, the win rate is about 20% right now. But for suspensions, if you look at the data closely, which I've done for a forthcoming paper, the win rate for suspensions was 6%. So it was, the courts pushed back on this, but it's a strategy that does work if an agency is willing to issue serial delays. So what are the lessons for the next administration? What the existence of these three tools means is that the Biden administration needs to think about the pressures at the end of the 4-year term, needs to think about them now. And here's why. The CRA is a threat if you finalize your rule at the end of the term, in the last half of the year of the last of the 4 years. But rules can take 2 to 3 or more years to finalize. So that means there's no time to delay. It seems like it's a long way away, but it actually isn't if it takes this long to finalize rules. 2 minutes? Okay. Second, abeyances. The way to avoid that risk is to get your rule through judicial review. And that can take a year or two. So that means now the pressure is on to get your rule, out and litigated before the end of the term. And then the third tool, suspensions, is most effective against rules that are not implemented. And that means you need your rule out and implemented by the end of the 4-year term. For comparison, the Obama administration issued a rule to improve safety at chemical facilities, and that rule had really long implementation periods, as long as 4 years. There was another rule that restricted the pollution that power plants could emit in their wastewater streams. And that rule had implementation deadlines that were 3 years out. And because those rules weren't implemented at the end of the Obama administration, the Trump administration had a much easier job of rolling them back. So those pressures mean that the Biden administration, all these teams of people that Sally just told us about, are under pressure to get their rules out basically as soon as possible, and hopefully within the next couple of years. Okay, I'm going to turn it over to Amit.
Thank you so much, Bethany. Amit.
Okay, great. Thank you, Ricky. And I'm really thrilled to be joining such a stellar panel. and certainly thrilled to be on a panel that was organized by the Institute for Policy Integrity. I've long been a fan of the work of IPI, and it's been really crucial work, especially under the Trump administration in terms of pointing out the many flaws in the many rollbacks that we saw from the Trump administration. And so whether you call yourself a center or an institute, I just hope you all keep up the good work. I trust you will. So let me come back to a couple of different things that Sally and Bethany already raised. I think it really needs to be emphasized the scope and the scale of the work that needs to be done in this early initial period here, the first, let's call it the first 100 days, since that's the euphemism that most use. There is an enormous amount of work that is certainly a function of the fact that the Trump administration was very aggressive in its deregulatory agenda, and even at the end, potentially was even more intensifying the rollbacks in order to get them across the finish line before President Biden came into office. So I actually like Sally's analogy, the three-legged stool, but I would apply it not only before what takes place before inauguration, but after as well. There still is, and let me use what is kind of the focal point of the regulatory state Office of Information and Regulatory Affairs is just an example of where I believe the work will be the most intense, since that will be work that needs to be coordinated across agencies as they all try to transition into their new regulatory agendas at those agencies. Just at OIRA, there's going to be a lot of activity still to come in terms of personnel. Some of that has happened already, but it has not been completed. That needs to occur at the same time as what I will call agency review. And here I'm thinking most about the actions that were subject to the regulatory freeze memo that were already published but have not yet taken effect. There are going to be numerous such actions at each agency where decisions have to be made quickly as to what those agencies are going to do with that category of rules. That is a highly time-sensitive manner. Under the Reg Freeze memo, we will see roughly a 60-day delay in effective dates for all of those rules that were published in the Federal Register but had not taken legal effect under the APA. And within that 60 days, the agencies will be pursuing public comment on the substance of the rule and on the direction that the agency should take with respect to those rules. That is a very short time period, and OIRA will be coordinating much of that activity. So that's going to be, in the short term, a lot of work in terms of what I'll call, just to use Sally's analogy, agency review, initial agency review. And then policy. We've already seen the Biden administration in one of its day one action set out a new policy in terms of the OIRA review process and the role of cost benefit analysis. It was a memo called Modernizing Regulatory Review. So that also needs to be acted upon and fleshed out in the short term. I do think that might actually wait for a little later because of the breadth and scope of the work that needs to be done, specifically with respect to those rules that have had their effective dates delayed and could be revisited and potentially either revised or withdrawn as a function of the notice and comment process that's going to take place. So there's a lot of work to be done, and it needs to be done quickly. And so the scale and scope is something that I think should be emphasized. It's possible that the Biden administration is going to get some help from Congress in the form of, well, let me say one last thing. I actually think that the Biden administration, before I turn to the CRA, has done a very good job in terms of getting prepared for all of this initial activity. The regulatory freeze memo had an interesting provision with respect to some rules that potentially were agencies took actions to try to insulate those rules by using, in my opinion, in a highly questionable fashion, a good cause exemption under the APA to make those rules immediately effective. I had not seen that provision in previous reg freeze memos. And the other thing is that the Biden administration, I don't think I've seen this before, had actually put out a list of rules on day one that they were having the agency target specifically in terms of revisiting. That kind of highly specific list, I think, was, and to my eyes, great to see, and was an indication that there has been a lot of preparation going on to get the transition into the Biden administration's regulatory agenda occurring quickly. So now coming to the CRA, as Bethany mentioned, CRA was used many times by Republicans in 2017 after having been dormant for a long time. I think that will open the door to Democratic use of the CRA for the first time. Democrats have not successfully used the CRA for the up until now. Potentially, we'll see that here in the initial part of the Biden administration. It is time limited, so these CRA challenges, if they occur, are going to have to occur roughly by late spring under the Republicans. Their CRA window for the rules that they CRA'd at the end of that came at the end of the Obama administration ended around mid-May. I imagine that's going to be similar this time around as well. I think that the Democrats are, if they do use the CRA, they're going to end up using it fairly judiciously, and this is maybe more a function of the fact that Senate floor time is so precious. Now, the main advantage to using the CRA is, of course, you don't have to deal with the filibuster on the Senate side. But at the same time, it does eat up Senate floor time. Obviously, nominations are going to be competing for that Senate floor time. Staffing up the Biden administration is critically important. And so, that will be one limitation. There's also a complicated calculus that goes over that, that agencies and Congress and OIRA are going to have to work together to work through. So not all of the potential targets under the CRA are going to make sense. Meaning, if there are rules, for example, that were subject to the Reg Freeze memo that potentially will be revisited through that process, that allows the Biden administration more discretion to deal with those regulations, and that might mean that there's less need or value in using the CRA against those regulations, although they will still be subject to the CRA, despite being also subject to the regulatory freeze memo. As Bethany mentioned, there are a lot of strategies around that the Trump administration used around rules being challenged in court, currently being challenged in court, or where we'll see challenges in court, particularly with respect to some of these last-minute regulations from the Trump administration. That will also come into the calculus as to whether a CRA challenge makes sense, if there is, a strong potential for success through litigation and disposing of that last-minute regulation from the Trump administration. And then there could be other reasons to prefer APA repeal, or I should say repeal through the APA rulemaking process. One factor that might actually counsel in favor of the CRA is that, of course, under the APA, all of those rulemaking actions are subject to judicial review in the courts. Successful CRA resolutions are not. And for folks that are worried about the impact that an increasingly conservative bench under Trump could have on the Biden administration's regulatory agenda, this could be a factor that matters. Last, there are persistent questions around the feature of the Congressional Review Act that nobody seems to really understand, and there seem to be more questions than answers. I'm talking, of course, about the provision in the Congressional Review Act that prohibits agencies from issuing rules that are substantially the same as those that were disapproved under the Congressional Review Act. This has been an obstacle in the past to democratic usage of the Congressional Review Act, even when the so-called stars have aligned in the past, meaning unified control of government by Democrats. I wonder if that will change. We have seen now a couple of examples of the Trump administration issuing regulations that they claim are substantially different from regulations that were disapproved using the Congressional Review Act in 2017. So in a couple of instances, we have seen that actually, the Trump administration does not view the substantially the same prohibition as an obstacle to regulating in spaces where CRA challenges have occurred in the past. Generally, prior to that, most folks were just looking at the one example of the Department of Labor's ergonomics rule back in 2001 that was repealed using the Congressional Review Act, and the fact that the agency had never attempted to bring that back in any form. But now we do have a track record to go on. Still, obviously, there are questions with respect to what the actual scope of substantially the same is. I'll say my own opinion on this is that, I find it hard to believe that any kind of fair or plausible reading of the term substantially the same would lead one to conclude that, whatever regulation that a Biden administration may potentially issue after a similar regulation from, or I should say after a regulation from the Trump administration was repealed using the Congressional Review Act. It's hard to imagine that whatever the Biden regulation is going to be in the wake of the Trump regulation being CRA'd is going to be substantially the same. I think it's probably much more plausible and fair to assume that whatever the Biden regulation is going to be substantially the same than the Trump regulation that was disapproved using the CRA. I would like to see further discussion if we have time for that. And I'll stop there.
Great, thank you so much. I mean, so I have sort of a few kind of random thoughts about these talks, and I think I will mostly talk about issues or strategies around the Congressional Review Act, just because these are decisions that have to be made right away. Restarting the regulatory process also has to start right away, but it's not going to finish right away. It's kind of a lengthy process, as Bethany explained. The CRA process, as Amit explained, has to start and finish quickly because under the statute, there are only 60 legislative days to finish it. And exactly what counts as a legislative day and how many there'll be and all that, we don't know all that, but by sometime in April, it will be done. Whereas to actually promulgate a new notice and comment rule could easily take 2 years. So we'll have like more time to, to think about this along the way. So a few things about the CRA. There is, in many conversations I've had over the last 6 months, I've noticed a certain democratic squeamishness about the CRA. And I think that's a really bad mistake. And I think we have to understand what's behind it, and we have to combat it. So the squeamishness comes in part because there's a view among Democrats that the CRA is a bad tool. It has kind of bad provenance and came into being with Newt Gingrich's contract with America in 1994. It had an obvious deregulatory bent. And, I think there are a lot of people in the Democratic Party who would like to see the CRA repealed. I actually also share the view that the CRA probably is a bad tool. But while it's around, it's there for both sides to use. Look, I'm a professor of administrative law, but I would never say that I prefer to preserve administrative law niceties to getting really bad policies off the table in an effective way, if that's what can happen. There is this concern about what substantially the same means. As Amit explained, a new regulation cannot be promulgated following the disapproval of a regulation if the new regulation is substantially the same as a disapproved regulation. No court has ever adjudicated what this means. No one really knows. Some people speculate. Now, I want to underscore an important point that Amit made, and then I want to actually go one step further. So the important point is, basically, the Trump administration's regulatory policy was to undo the Obama administration's regulatory policy. They didn't really have much more of a regulatory policy in mind. So basically, greenhouse gas regulations, the Obama administration regulated, the Trump administration either repealed those regulations or significantly weakened them. The Biden administration's regulatory policy is not going to be merely to put back in place the Obama administration's regulatory policy. How do we know that? Well, we know that because of lots of things that were said in the campaign, for example, in the climate change front, extremely ambitious goals, And we also know that from things that have happened in the last week that the Biden administration has been in office. In many of these areas, the Biden administration will seek to strengthen and expand regulatory policies of the Obama administration. And, you know, a lot of judges are textualists now. If you think that the baseline was the Obama policies, the Trump administration weakened them, weakened the baseline, the Biden administration would strengthen the baseline, it would do the opposite of what the Trump administration did. And no dictionary would tell you that the opposite means the same as substantially the same. It means the opposite of that. So, you know, clear textual analysis would tell you that we probably don't have to worry much about it. Now, could there be some rule where, you know, the Biden administration doesn't like something the Trump administration did, but the changes would be marginal? Those could exist. I can actually think of some. And those would be bad candidates for the Congressional Review Act. But there's actually an even more compelling category for Congressional Review Act action, and I'm going to I'm focused on it because I actually published an op-ed about this morning in Bloomberg Insights, and these are what I call these rules have two characteristics. One is that they just don't need to be replaced. We lived really well in this country without rulemaking in this area until now, and we will continue to live extremely well without replacement rules. That's kind of one thing. Second thing is, I call them meta-deregulatory. It's not that they just do mischief in the area in which the rule was promulgated. They do mischief in a kind of much broader set of areas. So if we don't get rid of them quickly, they're going to place hurdles for a whole set of possible regulatory actions. And the third, actually, beauty of all this, because the Congressional Review Act is really kind of should be analyzed as a game theoretic exercise, that while there's no reason why the Democratic president would ever want to replace those rules, there is some reason to worry that a Republican president might want to do similar mischief in the future. But once a rule like this is disapproved, similar mischief, or to use a statutory term, substantially the same mischief, we precluded by the Congressional Review Act. So not only would it put no roadblock on anything that a Democratic president would want to do, it would put roadblocks on things future Republican presidents would want to do. And that's kind of the beauty. And I'll just mention what these rules, you know, these rules, by the way, we don't even have to worry about whether they fit under the CRA window. The CRA window started on August 21st. Any rule published in the Federal Register on August 21st or later is subject to CRA disapproval. These were all published in the last month. In fact, one of them was really published the last day. And I think that they knew what they were doing. Sort of having lost the election, they rushed to do this sort of across the board mischief, which they may not have, you know, quite rushed to do in the same way. So first rule I have in mind is what I call the censored science rule, is an effort by EPA to exclude epidemiological studies of the adverse consequences of pollution if the underlying medical data for those studies is not publicly available for everyone to see. This is extremely pernicious because no one would, in their right mind, would agree to be the subject of the epidemiological study if all of their health information for the rest of their life is going to be accessible to everyone in the country. We lived really well without any rule like this before. EPA has policies on how to deal with science. The scientific community has policies and so on. Doesn't need to be replaced. We didn't have one until now. We'll do fine without it. It should be CRA'd, and a Republican administration won't be able to put a policy like this in place again. A similar rule deals with how to do cost-benefit analyses of clean air regulations, and it's an effort to exclude the indirect benefits of regulation or the co-benefits, also very bad. Inconsistent with standard economics. There's no respectable economist who thinks it's a good idea. No such rule in the past. We don't need such a rule to do good policy. It'll stand in the way of future mischief. Third, an Energy Department rule blocking stringent energy efficiency standards for furnaces, water heaters, and boilers. The Trump administration said that you can't redefine a category, and a category that actually be more energy efficient would be a different category, so therefore you can regulate this category. So it would essentially make it very difficult to regulate in this broad swath of appliances that have really bad energy efficiency consequences. Next rule, EPA promulgated a rule that would make it impossible for EPA to regulate the greenhouse gas emissions of any industrial class at all, other than power plants and oil and gas installations that are already regulated. You might wonder, how in the world could they do this? This wasn't proposed, so this kind of like fits in with my hypothesis. They were never planning to do a rule like this had they not lost the election. It wasn't proposed, so arguably this rule could get struck down on the grounds that there wasn't fair notice. They decided that no single class of stationary sources that contributes less than 3% to total greenhouse gas emissions is significant, and therefore cannot significantly harm human health and the environment. They had never planned this. They got around to doing this on January 13th. And to show that these people were hardworking up to the last minute, on January 19th, they promulgated what must be the most absurd rule of the Trump administration. It's the Department of Health and Human Services rule that triggers the automatic revocation in 5 years of all HHS rules that are 10 years or older, unless retrospective review is done on each of these rules, when everyone understands that the department does not have the resources to do retrospective review of these rules. And everyone also knows that historically, such retrospective review has been done on a minute set of rules. It's kind of an effort, which obviously won't succeed for a number of reasons, but Congressional Review Act disapproval could be a good one, to basically get rid off the books of essentially most HHS regulations, including by then it would be a lot of the Affordable Care Act regulations. I mean, it's really an effort at wholesale government destruction. So I think any squeamishness about using the CRA should be set aside. We should do it to the extent it works. We can't do it, as Amit said, across the board. And we should not worry about the future consequences, because we can define categories for which there are no future bad consequences. Let me ask the panelists whether they want to, have other reflections on what people said, and before we open up questions. So Sally, we'll go first. Sally, you're muted.
Thank you. We seem to be spending a lot of time on CRA, so I'll put my 2 cents in here. And I think I'm closer to Amit than I am to Ricky and Bethany on this one. I want to emphasize a point that Amit made, which is the time. The Republicans will require that they at least get 5 hours on each rule that comes up. Time is the most precious commodity in the Senate. And that was the reason that the majority leader, Reid, or the House, Senate Majority Leader Reid refused to do any Congressional Review Act when the stars were aligned with Obama. He said, we have an economic meltdown. We have hundreds of nominees we have to deal with. We don't have time. Go figure it out some other way. We now have not only hundreds of nominees and the meltdown, but we also have the pandemic, and we also have race relations, and we also have climate change as priorities. Excuse me. And we also have an impending impeachment, which is going to take up an awful lot of time. So how many you get through will be up for grabs. And I agree with everybody who says it can't be used indiscriminately. Ricky gave us a few very good examples. But last word on substantially similar. I agree that going backwards is not the same as going forwards. And it's not substantially similar. But we are a litigious country. And I will guarantee that somebody or buddies will bring this issue to the courts. And if they find the right judge, can get a stay. And all of the good work and expedition that Ricky rightly touts of the CRA may well be gone. Now, some of the rules that Ricky was talking about are what I call rules on rules. And there's a tiny little provision in 553 that exempts process rules. and this is an area which has gotten a lot of attention recently, but is still very ill-defined. I would say that all but maybe the HHS rule, which is truly pernicious. If you can have degrees of perniciousness, but in any event, the other rules, the EPA rules, could all be construed and in fact are justified by the outgoing administration as procedural rules, which do not need notice and comment. So they could be treated like guidance for those of you who know the difference between a substantive rule and guidance. Substantive rule needs notice and comment. Guidance, no. Just the stroke of a pen by the general counsel's office can change guidance without any notice or comment or delay. And so you can have some of these rules on rules that Ricky has identified disappear very quickly. Will that be litigated? Conceivably, but standing on some of those rules, some of those challenges will be very tough to establish. And while I have railed against the use of standing to keep public interest groups from challenging bad, what I would call bad regs, it's nice to see standing being used as it was during the election cycle, even-handedly. And there were a number of conservative judges who would not allow Trump to challenge elections because of a lack of standing. And I submit that that would be at least a legal argument that would come to the fore here. Now, I don't think we're going to resolve this, but I suppose it's Ricky and Brittany against Bethany against Sally and Amanda on this one, although there's lots of room for compromise.
So I do agree with Sally, certainly in terms of the time constraints on the Senate side, on the floor time nominations. This is going to be certainly a competing interest, a huge competing interest. At the same time, I do tend to agree with Ricky that while the CRA should be used judiciously, there are certain targets that potentially make more sense than others and rise to the top, if you will. And the way I've been kind of thinking along these same lines as well over the last few months. The way I've been calling them are the more ideologically motivated actions from the Trump administration, and to the extent that rules fall into that category where we do not expect the Biden administration to pursue similarly, ideologically motivated regulatory actions, that there's less of a risk in terms of the substantially the same issue. I was a little surprised, I have to be honest. After the presidential election, I certainly expected a rush, a bigger rush of midnight, let's call them rollbacks in this instance, than in the past. We had a one-term president, had way more to get across the finish line than two-term presidents, and the Senate didn't flip. And so I was saying at the time, well, it looks like the CRA is off the table for all intents and purposes, and so the agencies may feel a little bit more emboldened to put out the the rules they want to at the end and have less fear of potential CRA challenge. And then the Georgia elections happened. And I think what was surprising is that we still saw the administration feel emboldened to put out multiple rules even after those elections with the CRA back on the table. And I certainly agree, particularly on the one that Ricky cited, the HHS sunset rule, which we've been very, very concerned about as well. That was a little surprising to me. I thought that potentially the administration would be concerned about potential CRA challenges. I'm wondering now if there was just an assumption that those CRA challenges wouldn't surface. So let me make one last point on substantially the same. So Ricky made the very important point that subject to all the caveats that we've been talking about with regards to what that phrase actually means, what substantially the same actually means, it's possible that particularly on some of these ideologically motivated last-minute rules, a successful CRA challenge will foreclose future administrations from future likely Republican administrations from pursuing similar minded regulatory proposals. If that is the case, then I think, let me take this one step further. Then I think there may be then an incentive for some folks who have traditionally read substantially the same as salting the earth for agencies in the future. That has been the conventional wisdom. There may be an incentive for those folks to start thinking, hey, maybe this is not the best idea for us to be reading the substantially the same prohibition as broadly as we have, or as conventional wisdom has suggested, because it will then certainly take off the table in the future anything that Democrats successfully CRA in the future, meaning for future Republican administrations, anything that Democrats successfully CRA this Congress. So I know this sounds like some indirect and extenuated logic, but I think there could be a path for a consensus and agreement around what the actual scope of substantially the same is, and frankly, either reading it more narrowly or potentially getting rid of that piece of the CRA, because there will be interest in quarters where maybe there wasn't in the past, since Democrats have never used the CRA, to avoid foreclosing, let's call them deregulatory minded spaces for future Republican presidents in the future.
Just one.
Can I say something, Ricky?
Yeah, of course.
As Sally predicted, I think I am probably on Ricky's side here. And here's one thing to think about. I mean, there's a lot of issues to air, obviously, but we're in an era of tit for tat politics, and it's an easy win. It's an easy win out of Congress. And if you're thinking about trade-offs, like if it's a trade-off between political appointees versus helping political appointees, maybe it's worth it to do something. And maybe it's worth it to have the political win. Not that I'm a political expert, but it is all politics.
Well, we had a great debate on this issue, and I don't want to deflate it by saying that actually we kind of agree on pretty much everything. So maybe we shouldn't have called it like, Bethany and Ricky versus me and Sally. Because look, here are things we all agree on, I think. First, that we have to be judicious about the expenditure of Senate time. There are all kinds of other things, some of these regulations are really terrible, but they're not more important than something else that could happen in that time. And in particular, a COVID recovery, the passage of a COVID recovery bill. So we have to be very judicious. We have to have a way of ranking them. That's, I think, is important. I mean, I think, because there's been all this discussion about substantially the same, that should indicate that a very strong claim on CRA time should be for regulations that don't have to be replaced, that this administration will definitely not replace. It's not going to deal with that problem. And if in the process it puts some roadblocks on future Republican administrations, the better. So I think we also agree, although we haven't all said this exactly, that the optimal number of CRA disapprovals for the Biden administration to seek is not 0, but is greater than 0. It would be a mistake not to use it. And so therefore, it's kind of a question of ranking. And I'm sure that there are a lot of people doing that right now as we speak, both in the executive branch and in Congress. And I think whatever people who are focused on this can do to eliminate misconceptions and to kind of just give good legal advice, with all the uncertainties about what provisions that have never been interpreted by the court might mean, the more informed the decisions will be. But I think it is an important conversation to have. Okay, so I'm going to now go to questions in the chat. There are 2 so far, but please keep adding others. There's no statute of limitations to adding others. Oh, there's a 3rd one right now. I'll start with the first one from Mike Myers to the panelists. Any tips for agencies on how to get rules done relatively quickly without sacrificing accuracy or creating legal vulnerabilities? We know that many of the early Trump agency losses were due to acting hastily and not doing their homework. An excellent question. Who wants to tackle it first? Sally.
I'll offer one piece of advice. In those instances in which the agency would like to undo the Trump undoing, the Obama era regulation was presumably based on a very thorough, thoughtful record. That record should be resuscitated, revived, whatever you want to say, and added to incrementally, at least, to be brought up to date. Because under the Fox News standard, to undo something, you can change your mind. You just have to say, A, we're changing our mind, and B, why you're changing your mind, and the basis on which you're changing your mind. And I would submit that the best basis for changing your mind is the validity of the record that supported the Obama era regs, because they had a phenomenal record of well-documented scientific, economic, legal basis for going forward. And the reason the Trump record on appeal was so bad is they never talked about it. They never countered it. They never were able to offer anything on the other side. So we can go back to what we have, beef it up, and I think that could expedite everything a lot.
Yeah, I want to weigh in. I totally agree with Sally. You know, the record is where the action is. You know, I think it's really interesting that the Trump administration rolled back some rules by citing policy or citing a new statutory interpretation and trying to brush that record aside. And so in that case, the new rollback has both, you know, the Biden administration can both adopt a new policy and have a record to support it, which is powerful. And I guess I'll say, you know, as a tip, you know, I would recommend, you know, at least a quick notice and comment process. That's the thing that tripped up the Trump administration so much, you know, trying to avoid notice and comment. But it doesn't have to be long. You know, there was a rule that the Trump administration issued with a 4-day notice and comment, and the court said that that was too short. But there isn't really that much of a minimum. You know, it could be quick. It could be 10 days, it could be 15 days, it could be 30 days. It doesn't have to be a long-winded process. And then they need a record, right, to support the new decision. And they've got the Obama administration record. I'm so glad that Mike asked this question, because I have my new job at a center now, which focuses on the powerful role that state AGs play on the federal field. And the state AGs are there to help build these records to support these new federal policies that you know, help AGs. And that's the way to get your record, and that's the way to get your rule out quickly.
Great, thank you.
I'll just add very quickly, you know, the one strategy that came out of that excellent article that Ricky, you and Bethany put together, you know, these indefinite delays of effective dates, that is certainly one strategy that I think the Biden administration needs to avoid. And clearly the track record on that is that courts will not accept those.
Great. Thank you. The next question is from Hamden Macbeth. And it is, would any prohibition on a substantially the same regulation under the CRA be in any way enforceable if the judicial review provision prohibits the courts from reviewing any action taken under the CRA? So another really good question. And again, we have to speculate because the courts have never actually interpreted anything about the CRA. But I'll give you my interpretation, which is the following: that the prohibition for judicial review in the CRA is about the way that Congress conducts its reviews. So let me give you a specific example. On the science transparency rule, Andrew Wheeler, the EPA administrator in the Trump administration, today gave a talk at one of these right-wing think tanks and said, oh, this regulation cannot be CRA because it's a procedure rule and there are these other things. It doesn't affect any parties and whatever, doesn't fit under the rule definition of the CRA. And then some reporter called me and asked me, well, what do you think about what Administrator Wheeler said? And my instinctive reaction was always, well, I actually disagree, but then I kind of figured I should say more. And I said, look, you know, at the end of the day, the decision maker on what is subject to the CRA is a majority of the House and a majority of the Senate, and not Administrator Wheeler. And if Congress decides to vote to disapprove a regulation, and someone then challenges that disapproval by saying, oh, this wasn't a rule that could have been eligible for the CRA, I think that's what the prohibition of judicial review means. Just like, for example, there are, we're familiar with prohibitions of that sort. Compliance with Executive Order 12866, under which OIRA reviews it reviews major rules, is not judicial reviewable. So someone can't say, oh, OIRA didn't do this right or didn't comply with this provision of the executive order, and there's no judicial review. On the other hand, when an agency relies on a study submitted by OIRA to justify its rule, that is judicial reviewable under the arbitrary capricious standard of the Administrative Procedure Act. I think that if an agency promulgates a new rule and someone challenges the agency action on the grounds that that rule is substantially the same as one Congress disapproved, my prediction is that the courts would decide that that decision was judicial reviewable. And I assume that is the governing consensus, because otherwise no one would worry about what substantially the same means, and people are worrying a lot. So I think implicitly, at least, they must think that this is reviewable. Now, to Hampton's question, are we sure? No, we're not sure, because no court has ever said anything about this. Any other panelists want to comment on this issue? Okay, we can go to the next question. The next question is really terrific because of the way it starts. It starts out by saying, I agree with Ricky, so I think it's extremely well done. And it says, and don't object to using the CRA under the circumstances, but are the stars truly aligned given how razor thin the Democratic majority is? Passing CRA resolutions would probably take all votes of all 50 Democratic senators plus VP's tiebreaker. Joe Manchin has made crystal clear that he will vote against anything that hurts coal, a defect they will probably assign to any climate-related CRA. What if there is a Democratic senator for other issues that will have a major campaign contributor who will make them feel compelled to oppose? So question for panelists is, how usable is this tool really given the near stalemate in the Senate? That said, the procedural rules that Rick enumerated seem the likeliest candidates, maybe the science and transparency ones and HHS. Does anyone want to address Richard Parker's question?
Well, I'll just say, I do think that one of the things that the CRA certainly introduces into the regulatory process, or I should say regulatory policy, is politics, okay? The CRA challenges are going to be driven by politics, or at the very least strongly impacted by them, whatever the merits are or lack thereof of the rule being challenged using the CRA. So I'll give you an example. It is true that Joe Manchin, has not been that supportive of climate action, generally speaking. On the other hand, there is a very bad public health threat in West Virginia with respect to that toxic forever chemical, PFAS. And so for something like the secret, or I should say the science transparency rule, this could be something that could still appeal to somebody like a Joe Manchin, because certainly restricting science doesn't just relate to climate action that we hope will come from EPA under this administration. It also will apply to many of the regulatory actions that this administration hopefully will take with respect to PFAS. So I think there are avenues to potentially make political appeals on some of these CRA challenges. That said, it could be a case-by-case type situation.
Sally.
Two quick points on that, I think. One is that one of the jobs of the majority leader, and it would be Schumer now, is to protect his members from having to take tough votes. And so not only does he have to worry about the resources and the time and the capacity of the Senate, but also not putting Joe Manchin into an impossible position. Having said that, I would just add that I always thought that the part of the Congressional Review Act that was terrific was that you had to vote on the record. And by gosh, we would show those bastards who voted against whatever it was we thought was a good rule. And you know what happened with the 17 or 16 CRA votes that the Republicans took on Obama era regulations? Nothing. Not one of the senators who had voted to CRA, even the most ludicrous votes during the first couple of months of the Trump administration, even faced questions about that during their debates with candidates. The public has a very short attention span. And what we think is big things, and no senator would, oh, no, there's a no. No, I think there's going to be no price to pay for some of the votes that would be taken. So yes, it's politics, but it's a weird, short-lived political calculus.
Yeah,
I'm definitely on Sally's team with respect to that comment.
me too. But just one other observation. First, I would not attribute to Senator Manchin hostility to all climate change regulations. I mean, he is protective of coal, and he has a significant part of the economy in his state to worry about. But his track record, for example, on regulation of oil and gas is actually quite different. And so, for example, if the issue was the disapproval of the methane rule, the rule that limits, the Trump administration's rescission of an Obama rule that limited the methane leaks at oil and gas installations, I don't have any reason to believe that he would necessarily be opposed to that. And certainly some of these like really terrible government rules, like, as Richard indicated, like, the HHS rule, I mean, there's really no, it has no particular impact on coal industry. And there are a lot of people in West Virginia who actually have serious health issues. And I think he would worry about, what dismantling the HHS apparatus would do. So I wouldn't attribute any particular kind of across the board vote for him, even though he is somewhat more conservative than the median Democrat. I mean, and we do live in a hyper-partisan world, I recognize that, but I wouldn't go into this assuming that there are no Republican votes to be gotten. Actually, there was some crossover voting on the Trump on the Trump CRAs. I mean, there was one rule, one environmental rule, in which where the disapproval was defeated in the Senate, with John McCain voting against disapproval. And actually, there was one where Lindsey Graham voted against disapproval. So I wouldn't assume that there is no Republican senator out there that on some of these rules wouldn't actually vote to disapprove. So there could conceivably be, one Democratic defection and then kind of one Republican making up for it. I mean, obviously, the correlation between vote and party is going to be very strong, but I don't think it's going to be 100%. And I don't think we should assume going in that it would be. And obviously these things will get, look, I think one thing that the president understands well is the functioning of the US Senate, where he served for a very long time. And while he might not be involved in these conversations, I'm sure he's put together a very good legislative affairs team in the White House that will prioritize this, and in some ways will not make some mistakes that were made not only by the Trump administration, made by the Obama administration as well, and not quite understanding the kind of workings of Congress. So I'm sure that by the time these things get teed up, they'll have a very good sense of, can they keep all the Democrats? What Republicans might actually be attracted? What is this going to look like? And I think the success rate for things that the administration actually ends up getting getting behind will be very high. Question from Hayden Hashimoto, which unfortunately has to be the last question because we have a 12:15 stop time. What do you think about the argument against a quick pullback of procedural rules like science benefit cost analysis? If they argue the rules need notice and comment, aren't they unlawful because the agency lacks authority? Does anyone want to tackle this? I mean, I would say that, interestingly, some of the rules that at the end, the Trump administration said, oh, these are just procedural rules, I think in part because they were trying to avoid them being subject to the CRA, were in fact actually adopted through notice and comment rulemaking, like the science rules adopted that way, the benefit cost rules adopted that way. Actually, I think all of the ones I mentioned were adopted through notice and comment rulemaking, although in some of them, there wasn't actually adequate notice for what they did. Like, for example, the rule barring the regulation of stationary sources for greenhouse gas emissions other than oil and gas installations and power plants. I think there will be a risk to proceeding as if these were procedural rules on the grounds that that's what Administrator Wheeler said. My guess is that Administrator Wheeler would probably like actually challenge the rule representing one of the regulated parties unless the ethics rule don't allow that, and make exactly the opposite argument. So I would get no solace in what they said. And I think these are significant rules. Some of them are already in litigation. So I think there can be a quick pullback in the way that Sally mentioned, that, it's kind of just bad science, it's bad economics. You wouldn't need to do a lot. So for example, in the benefit cost rule, there isn't a single respectable economist who thinks that what they're doing makes any sense. And so, or at least that excluding co-benefits makes sense. I mean, the rule doesn't quite do that across the board. So I think a quick notice, quick comment period like Bethany suggested, I wouldn't go with less than 30 days. I think less than 30 days is kind of bad. But then, you can respond quickly to these comments, and because you kind of know what the response is going to be. You really have no support in the economic literature. There's no reason to like create these hurdles. And so some of these can be undone, but I think in some cases, but there will be litigation after that. And litigation is time consuming, and that the administration doesn't have control over. So that's why I find some of these, like what I call meta deregulatory rules, to be good CRA candidates. Sally.
One very, very quickly, walk and chew gum at the same time. Take an alternative task. Proceed with both, calling it a procedure and redoing it at the same time. And if you get accused of hypocrisy, well, small price to pay.
Yeah, I'll say as a general matter, I think it can be perilous to rely on the Trump EPA's logic, just in general, and that could counsel in favor of a CRA for something like this, the science or the BCA rules.
Bethany, if you want the last word, you can have it.
It sounds like we're all in agreement on everything.
Great. Okay, so this is like the ideal panel discussion. We had a vigorous debate with vigorously stated opposite positions, but then realized that we were essentially in agreement. So what could be better? And it was such a privilege to be able to talk about these issues with Amit and Bethany and Sally. And thanks so much for our audience and for the really good questions. And I'm just sad that we couldn't be sitting in Greenberg Lounge and seeing all of you and chatting after the event, but I hope we will be in that world by next fall. So thank you so much for participating in the forum sponsored by Latham & Watkins and talking about regulation and transition.